Civil Judge, Junior Division and Law Examinations. Law of Evidence in English language. Today's topic for discussion is General Rule and Facts forming part of same transaction under sections 5 to 9 Indian Evidence Act 1872 or sections 3 to 7 Bharatiya Sakshya Adhiniyam 2023 to be effective from 1st July 2024. In this lecture, dear friends, I will have to discuss in detail five sections covering number of topics. This lecture is expected to be a lengthy lecture. Instead of uploading in 5 lectures, I want to make it possible to upload in one lecture. This very few will be lengthy lectures. Majority will be around 1 hour only. Before going to take up the topic, let me express my deep sense of gratitude and heartfelt thanks to you, that is my student friends, who are instrumental for making my channel for subscription of 15,800. This month my channel is going to cross 16,000 subscribers, and there are, in addition to that, number of students are making use of my lectures by sharing through the groups after downloading my lectures. But with your motivation and inspiration, I have decided to work hard. Dear friends, many students are requesting me to upload that particular subject, this particular subject and everything. So what all lecture subjects I have covered through 250 lectures, those who would be able to watch all the 250 lectures will be in a position to receive lectures from distinguished jurists, distinguished scholars in national and international seminars. They will be able to understand any textbook of high standard. They will be able to understand any topic very easily, and they will be very comfortable to prepare for preliminary exams followed by main examinations. They will be able to understand very quickly whatever coaching being given in competitive examination center for judicial services examination. They will be this my lectures will help you to activate their preparation to get through judicial services examination and go to court directly as judicial officer. In case they fail to become judicial officer, they may start their career as an advocate with very good knowledge. However, my lectures are lengthy lectures of 1 hour and above, but you may download it and watch them piecemeal, so that you need not worry. It is very difficult to watch all the 250 lectures at a time. What I suggest you is, as and when my lecture at present are being uploaded, you watch them. And pending lectures, once in a day or 2 or 3 days in a one lecture in a day or one lecture in 2 or 3 days, you may watch using the cell phone. You will be able to acquire very good knowledge. With this, you can comfortably uh, understand whatever is being in taught by the distinguished professors in prestigious law schools and everything. So, finally, let me take few more seconds. I don't think that he is taking other things rather than subject. So, subject you can read from book, but these words you cannot get from everybody. Now, what I want to tell you, dear friends, most of you are disappointed in not getting a medical seat. To become, to start medical profession, the students are spending nearly 10 years, more than 5.5 years for MBBS, including internship. Thereafter, PG, facing NEET, rural service, so many things they are doing. So, uh, after LLB of 3 years, first 2 years in 5 year course, social sciences, but 3 years only law subjects for 3 year course students and 5 year course students. Try your level best to acquire knowledge during student career. In case you could not learn enough subject during student career, immediately after getting your LLB degree, you get enrolled in as advocate and and join some competitive examination center for 1 year. Then you start preparation, or you may join LLM in university. During 2 years, you can join some, simultaneously you join some competitive exam center for competitive coaching and judicial service coaching. Within 2 years, that knowledge will be very helpful to you to get your handsome post graduation law degree, and will help you to get through competitive examination. Overall, you will get very good knowledge, very good knowledge. If you have background of my lecture, you can successfully you manage not only in competitive exam centers but also in LLM LLM course. And then you, after LLM, you may go to, you may join as assistant professor, that is law lecturer, in some university department or private college. Or or else, in case you get selected for judicial officers exam, you can directly go start your professional career as judge. So this is my advice, dear friends. So I request you to watch. Don't think that the Raga Surya Rao told to give coaching of all papers of judicial service exam. Only subjects only I will be able to tell, but these are I am teaching one by one. But for I delivered more than 200 lectures designed to law students law examinations. So you watch candidates appearing for judicial service exam are requested to follow my lectures uploaded till designed for law examination. On that, you may go in depth, uncovered areas, and appear for the ensuing preliminary exam, followed by main exam, and so on. Now, I wish to take up in this lecture sections 5 to 9 under Indian Evidence Act, and sections 5 to 9 under Indian Evidence Act, and section 3 to 7 under Bharatiya Saksha Adhiniyam 2023. But as up to this, so far as these four sections are concerned, there are no any changes, substantial changes from old act to new act, except change of the section in numbers. So in this lecture, I wish to take up section 5 under Indian Evidence Act, or section 3 under Bharatiya Sakshyadiniyam, that is general rule, section 3. What is the general rule? What type of evidence is permitted by Indian Evidence Act? What evidence is permitted, what evidence is not permitted is what section 5 tells us. Section 6 under Indian Old Act and section 4 under New Act deals with the doctrine of res gestae, facts forming part of same transaction. This is the first topic under facts forming part of same transaction. The first topic is the doctrine of res gestae. In this topic, the facts forming part of same transaction is found possible, but in others remaining sections, the facts forming part of same transaction are not strictly adhered to. To overcome this problem, section 7 under Old Act and section 5 under New Act provide for 5 more concepts, namely occasion, cause, effect, state of things and opportunity, section 7. Next, section 8 provide for 4 concepts: motive, preparation and conduct, previous or subsequent. In other words, motive, preparation and previous conduct or subsequent conduct, so which are present in commission of a crime. So 4 points, 4 concepts are covered under section 8. And the last section, section 9 under Indian Evidence Act and section 7 under Bharatiya Sakshyadiniyam, 7 more points, 7 more concepts are added. So they are introductory, explanatory and interrogatory facts. What are these facts? We will have to discuss point wise. Now, first of all, we should go to why. So in this lecture, I have decided to teach all these section 5 general rule and sections 6 to 9 4 topics in one, because there are the reasons I am telling you. Here in section 6, facts, res gestae deals with facts forming part of same transaction can be possible in respect of section 6. But this what constitute facts forming part of same transaction, it is it cannot be decided so easily. Sometimes difficulty arose to arrive at the conclusion what facts constitutes facts forming part of the same transaction. In order to resolve this difficulty, in order to solve this problem, section 7 in Old Act and section 5 in New Act provided five concepts, 5 instances, namely occasion, that provides commission of a particular principal fact or transaction. Secondly, cause. What is the actual cause for commission of a particular transaction or for happening of a particular transaction? Cause. Effect. What are the effects? Section 7 or 5 is principle of based on the principle of induction. When a particular act is committed, what are the effectual consequences? What are the consequences that are likely to follow. Suppose human body, a person, a man is murdered, an accident takes place, a man is killed in accident, that road is covered by blood. So when blood stained clothes are there, something, what if when a particular act is done, some effectual consequences will be there. What is the effect? How far effect is relevant under under Evidence Act for admission of an evidence? How far effect is relevant? How far state of things? How state of things take place? How it is relevant? And finally, opportunity. How, what are the circumstances for creation of an opportunity, that how that opportunity gives room for commission of a particular crime or happening of particular transaction. This section 5. That is why section 6 doesn't cover all aspects, but it covers, it is confined to particular area. In order to provide 5 more instances, section 7 is designed under same category, that is facts forming part of same transaction, to make the instances relevant other than directly, that section 7 is 7 provides, section 7 in old act, 5 in new act provide 5 more concepts. And section 8 provides when evidence is not clear, and there are three concepts, namely three concepts, namely motive, preparation, and conduct. The conduct may be previous conduct or subsequent conduct. So in a in an intentional crime, in a voluntary crime, motive and preparation are compulsory. That crime constitutes this preparation and motive. How they appear, we will discuss in detail. Conduct also, it is a circumstantial, indirect concept, that how far the conduct, previous conduct or subsequent conduct are relevant in the to relevant for admission of evidence, we will take up in the respective chapter. Next, last one is ninth topic, section 6 res gestae, section 6 old act res gestae, section 4 new act, and section 7 old act, 5 new act, occasion, cause, effect, state of things, and opportunity. Section 8 old act and 6 new act they provide motive, preparation, and previous conduct or subsequent conduct. Last section 9 under old act and 7 under new act provide explanatory and introductory facts. Under these explanatory and introductory facts, there 7 instances, 7 concepts have been provided for. So these are all these are the topics we have to discuss point wise. Dear friends, the fine evidence I told you divided into 3 parts. Part 1 section, let us discuss confined to old act only. But this academic year, the old act is being followed even for the competitive exams. But they are subject to slight changes. The new act will come from July 1st. Now coming to the first thing, as I told you in the first class, the evidence is broadly categorized into part 1, part 2, part 3. Part 1 is to somewhat technical, 5 to 55. The topics are technical, a little bit difficult. Part 2, means of proving, and part 3, mode of proving. Means of proving means 56 to 100. Mode of proving section 101 to 167. The part 2, part 3, the topics are comparatively easy. So that is why what I suggest you is you go through my summary lecture recently uploaded, or earlier long back I gave detailed summary in 3 lectures. If you follow that, it is okay. Then you go to part 2 and part 3, and finally you go to part 3. So in this part 1, preliminary section 1 to 4 I covered in one class. Section 5 to 9 I am covering now. Then after this, some other important topics are there. Section 11 is there, LB. Admissions 13, custom is there. Rights under custom, and admissions and confessions. Admissions way is there, 17 to 30. In that confessions in admissions in civil litigation, confession. So after this lecture, the important topics you have to discuss is admissions, confessions, and LB. And dying declaration is an important thing, and witness by evidence by third person, that is expert opinions. These are the main topics you will have to discuss. However, I will enlighten you each and every topic, what are more important from examination point of view. Now we have to discuss about section 5. I told you in section 9 there are 9 concepts. There are 7 concepts. Section 9 deal with introductory facts and explanatory facts and introductory facts. This section 9 contains 7 instances. Number 1, facts explaining facts which are necessary. Next, facts. Section 9 of the Indian Evidence Act or Section 7 of the Bharatiya Sakshya Adhiniyam provides for 7 categories of instances which are otherwise relevant to facts in issue and relevant fact. So if any fact falls under any one of these 7 categories, that particular statement is permitted to be permitted as evidence. That particular fact is allowed as recognized as relevant and allowed to be presented in evidence. These are the 7 things. So first one is facts which are necessary to explain facts in issue or relevant facts or explanatory facts. So there are first one is facts which are certain facts are very necessary for to explain facts in issue or relevant facts. Second one is facts which are necessary to introduce facts in issue or relevant facts. These are called introductory facts. Now, thirdly, facts which support the inferences. Third one is the facts which support the inferences suggested by facts in issue or relevant facts. Fourth one is facts which rebut or contradict or oppose the inferences suggested by the fact in issue or relevant facts. Fifth one is most important, identity, test identification or identification of persons, things, animals, etc. So sometimes this among these 7, test identification or identification of persons or identification of accused persons, identification of culprits. Suppose if any, I will explain everything in detail. Identification of persons, test identification or identification of persons, articles, things, animals, etc. will come under this point. This test identification or identification of persons is a very big topic. This identification alone requires explanation of 1 hour minimum. 1 hour minimum. So all these things I am covering. If you want me to explain test identification in detail, you put in comment. I will take separate classes. Even if these 5 sections are not clear, you may put in comment so that any particular section you want in detail, I will upload separate lecture. And next sixth one is sixth one is facts which fix time or place at which facts in issue or relevant facts are happened. So sixth one is facts which fix time or place at which fact in issue or relevant facts take place. This point refers to LB. LB is a very popular term. We in many movies basing on LB, the culprit tries to escape from the liability. When a person A is alleged to have committed some crime or murder, and he will take the plea of LB, saying that this murder was alleged to have been committed at Chennai at a particular center, but at that time I was in Delhi attending some conference, or I was unwell, admitted in some hospital, like that. So the same person cannot be available in two places. Two places. The LB is like a defense, but it is not in general defense, but it is LB like a defense to escape from criminal liability. If the person is not really culprit, the accused person is not really available at the scene of offense, but elsewhere, then the case will be dismissed. So that is LB. Facts which facts which fix time or place, fix time or place at which facts in issue or relevant facts happen. Last one is facts which show the relationship of parties by whom such fact was transacted. So this is with reference to ancestral friends and other relations, and this topic has no explanation, but it speaks about pedigree friends. Pedigree friends means ancestral friends. The relations are established. But what are the issues that can be taken for granted for relevancy? So, dear friend, these are the seven. These are the topics we have to discuss topic wise. This is introduction on section 5 to 9 or section 3 to 7. Now we have to take up this. So why we are taking up these 4 sections collectively? I tell you, section 6 is strictly adhered to facts forming part of same transaction. Every time it is not so easy to ascertain the facts forming part of same transaction. Then section 7 is you made use of providing 5, and then section 8 3 more topics are added. In section 9 section 8 3 more topics, motive, preparation were provided. In finally in section 9 7 topics have been added. This is for your information. Now we should take about the first topic. First topic, that is section 5. Now this is the time to discuss in detail section 5 to 9. 5, 6, 7, 8, 9. Section 5 Indian Evidence Act or Section 3 Bharatiya Saksha Adhiniyam provide for general rule. General rule in the sense, when a in civil litigation, when transaction takes place and a dispute takes place, the dispute is what is called fact in issue. So as a student of evidence, you must have thorough knowledge about what is fact, what is relevant fact, what is fact in issue. These three concepts I discussed again and again in previous lectures. So fact means fact. Now coming to the point, what facts are allowed to be, suppose when a transaction takes place, dispute, when a contract is entered into, dispute took place, the aggrieved party will go to the court. So transaction took place is a fact, and the creditor tells that he gave 1 lakh to 1 lakh to debtor. Debtor tells that he has not received any money. So creditor telling says he has given, debtor says he has not given. That is the fact in issue. Taking or giving or taking money is the transaction, is the fact. And where some says, one says given, one says not given, is the fact in issue. When the issue takes place, then only the parties go to the court. When the parties go to the court, they have to they have to bring the supporting evidence. They have to bring the appropriate witnesses, and with these witnesses should give appropriate evidence. They should speak appropriate statement, correct statement. Those correct statements are called facts. The appropriate statements are called relevant facts. So, because of the reason that if witnesses can be presented, means a man on the walking on the road cannot be allowed to be presented. What kind of witnesses are allowed in court for giving evidence? What type of statements given by the witnesses are allowed is what Section 5 says. Section 5 says that Section 5 entertains only the facts which are in existence, directly or otherwise, are admitted in evidence. So the fact must be in existence. According to Section 5, what are the conditions? The court will accept, entertain witnesses with such kind of statements, provided the following conditions are satisfied. So the right witness should come to court, and right statements, appropriate statements, relevant statements must be given. These statements, that is the words spoken by the witnesses, must relate to the either fact in existence or otherwise they must be the facts. That means they are direct facts, or in the absence of direct facts, direct evidence, the court will accept indirect evidence. Because if anything is there, suppose some crime takes place, after crime is over, the culprit will run away, he is absconded. So there may not be any eyewitnesses. So that is why it is not possible in all cases to provide direct witnesses, direct documents. And in the absence of direct witness and in the absence of direct documents of original documents, the court will accept, entertain alternative source of evidence. So according to section 5 of the Indian Evidence Act, or Section 3 of the Bharatiya Saksha Adhiniyam 2023, a fact, an evidence to be admitted or allowed, the evidence given by witnesses, the evidence produced must be with reference to fact in issue. So it must be a fact in existence, directly or otherwise. Directly or otherwise means it may be otherwise means it may be indirect evidence, or it may be circumstantial evidence. Secondly, the fact must be a relevant fact. The relevant fact in the sense legally relevant, it must not be logically relevant. What is legal relevancy? What is logical relevancy? I explained in previous class. So it must be legally relevant. That legally relevant in the sense it must fall within the meaning of any one of the instances under section 6 to 55 of the Indian Evidence Act, or sections the sections 6 to 55 of Indian Evidence Act, or sections 4 to 50 of the Bharatiya Sakshya Adhiniyam. This is the point. So, so these are the up to 9, and 9 or 10 is there, a conspiracy, 11 is there, LB, 12 is there, suit for the contractual issues, 13 is there, custom, and so on. So many instances are there. 14 is there, bodily feeling, like this, intentional bodily feeling, and it will continue like that. So the up to 55, 55. So the fact must be in existence directly or otherwise. Secondly, it must be a relevant fact. Relevant fact in the sense legally relevant within the meaning of section 2 to 50, section 6 to 55 under Indian Evidence Act, or section 4 to 50 of the Bharatiya Sakshya Adhiniyam. But Bharatiya Sakshya Adhiniyam not necessary here, but for your convenience I am telling, because with a view to inculcate that these, so far as this area is concerned, the law is not changed. The same is repeated in the new act. Same is repeated in the new act. So this third one is other than this, that evidence is not allowed and that is not relevant, deemed to be irrelevant, the court will not accept. However, there is some explanation and exception. So what is that explanation and exception to this rule? If number 1, section 5 is not applicable to those cases where the persons are disentitled to give evidence according to Civil Procedure Code. The Code of Civil Procedure, there's a code provide for the Code of Civil Procedure provided some exceptions. So the evidence, these persons are not qualified to give evidence, are not qualified to give evidence. What are they? Dear friends, in every penal provisions are there in Indian Penal Code. Penal provisions are there in Dowry Prohibition Act, Domestic Violence Act. Penal provisions are there in Workmen Compensation Act, Industrial Dispute Act. Penal provisions are there in Indian Companies Act 1956 followed by 2013. So every special act will have penal provisions which are identical to the Indian Penal Code. So like that, so every act will have its own law. But here, according to Civil Procedure Code, the Code of Civil Procedure is the general law. It provides rules and regulations as to procedure. What type of witnesses are allowed to give evidence, what type of statements given by the witnesses are allowed in evidence, what are they, they will tell. What kinds of evidence witnesses are not qualified to give evidence, what type of statements are not qualified to be allowed, were provided under Civil Procedure Code. Civil Procedure Code. What are these provisions? Section Order 7, Rules 14-18. Order 13, Rule 141. For Rule 1 or 41. Rule 27 of CPC. So here, so it is not the CPC, the Law Commission 69th report they are telling, better not, don't use the expression Civil Procedure Code or Civil Procedure. So law of the land is good, but there may be so many other laws. Specific Relief Act may be there, Specific Relief Act may be there, Limitation Act may be there, and so many civil piecemeal legislations may be there. They may provide certain rules of evidence and exceptions, etc. And so, for example, Arbitration Conciliation Act, the rules of law are not applicable here. For arbitration affidavits, these are not applicable. So that is why, so far as section 5 is concerned, the court will accept or entertain the evidence provided the fact is in existence directly or otherwise. That means indirect or circumstantial evidence or even hearsay evidence may be allowed. Second thing is, it must be relevant facts. They should not be logical, first point. Legally relevant in the sense it must fall within the meaning of section 6 to 55 of Indian Evidence Act, or section in future section 4 to 50 of the Bharatiya Sakshya Adhiniyam in future. So that is the rule. And third, others are deemed to be irrelevant. So whatever items are prohibited under Civil Procedure Code, now according to 2069th report, law of the land in force, that evidence cannot be accepted by the court. And one more point is there, Jammu and Kashmir. At the time of constitution came into force, the Jammu and Kashmir, the state of Jammu and Kashmir was conferred autonomous status, independent status on some political reasons. That is why every enactment, the opening words say, this law is applicable, this act is applicable to whole of India except the state of Jammu and Kashmir. The except the state of Jammu and Kashmir is no more with the abolition of Article 370. Article 370 of Indian Constitution gave independent autonomy to Jammu and Kashmir. This particular Article 370 was abolished in 2019 by the Jammu and Kashmir Reorganization Act, and now this state of Jammu and Kashmir was made union territory, and hence there is no exception to this. Section 5 Indian Evidence Act is applicable to Jammu and Kashmir, but Section 5 Indian Evidence Act is not applicable to Section 5 Indian Evidence Act is not applicable to some of the provisions under CPC or any law of the land in this thing. So this is now coming to the next topic, relevancy and admissibility. Relevancy, the question of relevancy is a question of law that can be raised at any stage of the proceeding, civil proceeding or criminal proceeding. So by the time the question of relevancy, one party says relevant, other party says irrelevant, whether the court is under impression to entertain the relevancy of anything till the final stage, even at the end peak stage also the opponent can challenge the relevancy. That is why the question of relevancy is a question of law. The courts must be very cautious, because the relevancy, the genuineness of relevancy can be questioned or contradicted at any stage, right from filing of the case to ultimate judgment, trial, completion of trial stage. So that is why. That is why the courts are, suppose in a criminal law, first FIR. If otherwise complaint will be lodged, then investigation will be started. Next inquiry, next trial. After trial, judgment. After judgment, either conviction or acquittal. If judgment, if conviction, jail. Acquittal, home. Like this, there are various stages will be there. Like that, the question of relevancy can be challenged. If the relevancy is proved, if its relevancy is admitted, then only the case will be, that evidence will be admitted. So the next stage of relevancy is admissibility. So in a case or proceeding in civil litigation or criminal proceeding, part 1, relevancy, the evidence given by the witness must be relevant under section 6 to 55 or in Indian Evidence Act, or section 4 to 50 of the Bharatiya Saksha Adhiniyam. Similarly, then when once first stage is over, the second stage come to proof of the evidence. Proof. The court will accept it. Okay, your relevant, the evidence given is relevant. We admit. Then you have to prove it. Prove. Who have to? What are the means of proof? Who will have to give evidence? Who are qualified to evidence? Who can be compelled to evidence? Who can be called for evidence? Who can be called for evidence with the permission of the concerned authorities? Who must not be called or compelled to called for evidence. These rules are there. And the third stage, there are procedure of evidence, examination in chief, cross examination, re-examination, and other processes are there. So if first part is completed, relevancy is completed, followed by the admissibility. Part 2, part 3 is successfully completed, the process of proof is completed. Once the process of proof is completed, the next stage is whether the proof and process of means of proof and process of proof, okay, the fact is said to be proved. If the relevance is okay, first means of proof is okay, but mode of proof is not clear, then it is disproved. Then when part 1, part 2, part 3, all the three processes are successfully completed, then it is proved. If any stage is not completed, it is disproved. If it is a civil case, it is proved, the case will be, the person who went to court is given decree or order. So if it is a criminal case, the prosecution proves, the accused will be convicted. If the prosecution failed to prove, the accused will be acquitted. This is the stage. Stage. So that is why, what is the distinction between relevancy and admissibility? Relevancy is the first stage, admissibility is next stage. But in admissibility, relevancy is there. Admissibility contains relevancy, but every relevant fact does not contain admissible fact. So that is why it is said that all admissible facts are relevant, but all relevant facts are not admissible. So the evidence may be stopped at relevant stage. If it is not, it will go. If relevance is okay, means of proving, it may be stopped at means of proving level, or it is a successful second stage, third stage, it may be there. So just like calling for application, you must be law graduate, that is criteria to apply. After apply, written test, screening test. If screening test qualified, main qualified, interview selected or not selected, like proof or disprove. Then appointment order will be given if selected, otherwise silence if not selected. So these are the like that. You have to think with this. Section 5 is over. Dear friends. Now next topic for discussion is section 6, res gestae. Section 6, res gestae. Now section 6, res gestae is a very, very important topic from examination point of view. Section 6 of Indian evidence, the first concept under facts forming part of same transaction is section 6 in Indian Evidence Act, or section 4 under Bharatiya Saksha Adhiniyam. So section 6 of the section 6 to 9. Section 6 to 9 lay down, provide for various ways in which the facts connect to the situation which form part of the same transaction. In other words, section 6 to 9 lay down various means in which the facts are so connected with the main fact that form part of the same transaction. So under the category of facts forming part of the same transaction, four topics are there. Section 6 risk geste, Section 7 occasion etc., Section 8 motive etc., Section 9 explanatory and introductory facts. So like that, the first of this kind is facts forming part of same transaction is Section 6. Section 6 Old Act, Indian Evidence Act, Section 4 New Act, Bharatiya Sakshya Adhiniyam, deal with the doctrine of doctrine of res gestae. The doctrine of res gestae are the facts forming part of the same transaction is the topic. This doctrine of res gestae, Section 6 is very important from examination point of view. This res gestae refers to indirect evidence or circumstantial evidence or hearsay evidence. According to Section 60 of the Indian Evidence Act, hearsay evidence is no evidence. It is one of the three fundamental principles that hearsay evidence is no evidence, and Section 60 enunciate that hearsay evidence is no evidence. What is hearsay evidence? I had already told you in the previous classes. Let us now discuss about the historical background of the crucial concept, the doctrine of evidence. The word res gestae was used for the first time by the Romans to use things done, acts to mean acts are done. The word, the term, the concept res gestae was used for the first time by Romans for the usage for acts are done or acts. Later, American and English and American jurists described res gestae as facts forming part of same transaction naturally or automatically. They also said that the res gestae is like recepsa lacutor and law of torts is a thing that speaks for itself. In law of torts, I explained the thing tells its own story. So separately, it need not be proved. Suppose Delhi Municipal Corporation versus Subhagwanti, there was a old tower, more than 100 years old tower in Chandni Chowk. Its lifetime is 50 years, but it even 100 years has elapsed. It was not demolished. At any time, it may be collapsed. That is what I taught in law of torts. So the thing itself. So that is why res gestae is the word. Res gestae is a Latin word which means thing. Res gestae means thing done. Res gestae means part of the story. Part of the story. So in other words, res gestae means fact story behind. Fact story behind. There is something indirect inner meanings or something. All days these people are very cruel. Suddenly how they become good? That is, there is something they want to do something wrong. The man is always angry. Today he is cheerful. What is the reason? Some res gestae is there. That is what we have to listen. So now, in law of evidence, res gestae means things done, including words spoken, forming part of the same transaction. So far as the res gestae is concerned, facts forming part of the same transaction. The fact may be an activity, commission of an act, or speaking of the act. Commission of the act, speaking of the act. Suppose A beats his wife B. B cries, don't go beat me further, I will die. The words of B, wife, also form part of the same transaction. As if you say that I am beating my wife, I want to kill my wife. That words of A are so right. The act of A in beating B is right. So whatever if this witnessed by bystanders, that is also allowed. These people said to some others, that is also allowed in the subsequent cases under Section 7 under 9. All these things will be cut. So the facts forming part of same transaction in the sense the fact includes words spoken, but also not only acts done but also words spoken, not only at the same time but also at different times, not only at the same place but also at the various places. Dear friend, I am not reading out the contents of the section because it will take much time, so I am giving you the real content and meaning of these sections only. So there are certain circumstances in which a particular fact is not a fact in issue, but it connected with the fact in issue is relevant. So there are certain facts. Particular fact is not a fact in issue, but it is related to fact in issue. What is fact? What is relevant fact? What is fact in issue? You read again and again, and you get it digested like anything, so that you will be able to understand any literature in this subject. So now, so this is about now the question is what is the transaction? Now the question is what is transaction? Transaction constitutes group of acts. Transaction contains a group of acts, different acts, and also words spoken, and there must be nexus between one act to another. There may be causal connection. There must be proximity between one to another, nexus between the act to act and word to word, word to word. What are you telling? What is that? What are you telling? No. What you are telling is directly or indirectly connected to that particular statement. Then only it is accepted. Suppose a dead body is found. So this dead body, the one somebody told him to kill him, that is relevant. So in some other area, some other man, some other said to some other is not correct. So there may be, that may be the fact, this may be the fact, but the one fact and other fact must be connected to each other. There must be causal connection. Not only the causal connection must refer to not only the acts but also this thing. Now the question is, what is the transaction? What is transaction? Stephen defined transaction. A transaction is a group of physical acts and including words spoken having causal connection to each other. It is like a contract tort or wrong. It is like a contract tort or wrong. In a contract, two or more parties come together to enter into a contract or an agreement. In a tort also, it is a civil wrong. One person breaches his duty, it causes loss or damage to another. It is like a crime. In crime means one person commits an act and other person receives injury. So it is a transaction is a group, is a combination of some physical acts or activities or words spoken. There must be causal connection with another, one to another. That is why Stephen defined transaction. According to Stephen, a transaction is a group of facts connected together as to be referred to by a single name, such as is the group of physical acts known as contract, wrong, or other equitable wrong. So this is what Stephen, this definition given by Stephen was approved in many cases. Now, who are entitled to give such statements? Whose statement is relevant under Section 6 in Indian Evidence Act, Section 4 under Bharatiya Sakshya Adhiniyam. So the accused, the victim, the third person or bystander. Here, A is beating B. A is beating B to death. C is telling, don't beat further, he will die. So, A statement, I have decided to kill A. It is relevant and facts forming part of statement is direct. If not A, B tells. So, A committed when he was beating his wife B, I was telling him, don't beat, she will die. That is, B statement forms part of the same transaction. and see. But A, B, see, neighbor, he heard the voice. He heard the voice. Today, you die today. Today, you will be no more today. I will kill you today. I will kill you today. A is crying. And B, wife, no, don't kill me. Don't kill me. Don't kill me. Don't save me. And she will say, please save me, save me. She will cry. Somebody had. That word also is relevant. So that is why the accused himself, the statement made by accused is competent to make the statement. The statement made by accused is relevant, forms part of this transaction. The victim, the aggrieved party, is cries, screams, also form part of the same transaction. The third party, bystander, who have seen the offence, who are sitting wide, who are hearing from long distance, that also forms part of the same transaction. So, to invoke section 6 for forming part of the same transaction, some conditions are to be fulfilled. Number one, the state must be a statement of fact but not opinion. So, when the witness wants to give a statement relating to facts forming part of the statement, it must be a statement of fact. It is a true fact. It is not opinion. Yes, I know, sir, A threatened B to kill him within 1 week. That is statement of fact. No, A and B relations are not good, but we can assume that A might have killed B. That is opinion. That is not correct. That is not correct. A is a bad man. If somebody killed means he might have killed that man. That is opinion. That is opinion. So, there some B is there. If anybody gives him 10,000 rupees, he will kill anybody. So, he might have killed this man. That is opinion. That is not correct. It must be a statement of fact and not statement of opinion. Secondly, the statement should be given by the either participant or witness or some third party. Even statement by third party or bystander or witness is eligible. Last condition is when once a statement is with reference to facts forming part of same transaction under 6 is to be given, it must be clearly explain the event, transaction or situation so as to enable the court to understand the situation. Then only it is allowed. In view of this, there must be a nexus between the statement made and the transaction occurred. That is, nexus means causal connection should be there. Now we go to case law. There are so many cases, dear friend. One R versus Foster 1941 case. What happened in this case was the accused drove the vehicle very excessive speed and deceased met with the accident. This is hit and run case, and the accused dashed the deceased and ran away, but from long distance the witness bystanders having heard the sound voice, they saw only speeding vehicle. They went to the scene of the accident, but the accused is in lost state. He narrated the accident. Somebody in excessive speed hit me and ran away and then died. So it is just like dialing declaration. But however, whatever statement is the statement given by that is recorded by some official magistrate or somebody, it is treated as dialing declaration. It is taken by some third person and communicated to the police for taking up investigation and all. This is what is called res gestae. It is treated as fact forming part of same transaction and was allowed. Next, Hadu Samanta versus the state of Orissa is most important case in this point. Hadu Samanta is accused. Bhim Panda is deceased in this case. What happened was, Hadu Samanta accused told the deceased Bhim Panda, I know how to extract gold from underneath of the earth. if you give me some money, I will teach you how to extract gold from underneath of the land. Confidently believing, Bhim Panda gave some money, but accused Hadu Samanta neither taught nor returned the money. Once deceased, Bhim Panda went to his went to Hadu Samanta's house. As you did not teach me anything, you give back my money. Okay, you sit, I will give money. And he brought some sweet meat, so some food containing poison. He consumed it and died. He consumed it and died. Then the scene over. After few days, the dead body of Bhim Panda was floating on the village tank. Village tank. So how Bhim Panda died? Who killed? There is no any evidence. But it was somebody who was passing through that. This body I found. This body I found on a bullock cart in front of Hadu Samanta's house. The reason is, few days back I went to some market yard. I went to some market yard to for purchasing some goods, and when I was returning through the house of some Hadu Samanta, a bullock cart was lying in the middle of the road. When I cried to give side, there was no response from anybody. However, witnesses, prosecution witness 6, he told, no, on that bullock cart there is the dead body. Nobody will give you, take the cart side. You have to create side and go. Somebody told me. And then I had to take side and passed. I continued to start. This is what I can tell. This was treated as fact forming part of same transaction, and Hadu Samanda was arrested, interrogated, and ultimately guilt was proved. Like that, there are so many cases are there. Ravindranath Murthy Naidu versus a state of West Bengal. In this case also, the accused stabbed the deceased with knife and ran away. When the deceased is in last moments, some strangers found him, and some knife was still lying on the back side of the deceased, and with this statement was entertained as the statement was entertained as res gestae, and the culprit was punished. So sometimes when if your dying declaration to be admissible, the person making dying declaration must die. If the declarant survives, that statement is treated as res gestae. It was decided in third additional session judge versus Gantale. In that case, it was there. And another case is Vasa Chandrasekhar Rao versus Panna Satyanarayana. In this case, what happened was the accused killed his wife and daughter. Then accused father telephoned to deceased father, my son killed your daughter and granddaughter, But this statement was not admitted as res gestae subsequently due to some reason or other. But on the ground of some other evidence, the accused was convicted. With this, this is the case law. Now, last point under res gestae is res gestae and hearsay evidence. Res gestae and hearsay evidence. Section hearsay evidence is no evidence is the fundamental rule. One of the three fundamental rules is hearsay evidence is no evidence. I told many times in previous classes. And another thing is section 60. Section 59 and 60 deal with oral evidence. Section 60 enunciates that hearsay evidence is no evidence. However, there are some exceptions to this general rule. Means hearsay evidence also is admissible. Section 6, res gestae, is an exception. Next, section 23 to 31, admissions and confessions. Res gestae, hearsay evidence is admissible. Section 32, previous proceedings of the court. So the person who gave evidence in previous sitting of the court is not able to come this time. Maybe reason he died, maybe reason he is hospitalized, maybe the reason he is out of station, maybe reason he cannot be called again for giving evidence. That is the previous proceeding. And section 34, statements in books, that is evidence. Section 35, statements in public document. These are the hearsay evidence is allowed. Generally, the fundamental rule is hearsay evidence is no evidence, is not allowed in not admissible in evidence. However, there are similarly section 60 of the Indian Evidence Act enunciate that even hearsay evidence is no evidence, but there are exceptions. Section 6, res gestae, hearsay evidence is allowed. Section 23 to 31, admissions, confessions, it is allowed. Section 32, dying declaration is allowed. Section 33, previous judicial proceedings, it is allowed. Section 33, entries on books, it is allowed. Section 35, entries in statements in public documents is allowed. So from section 6 from 17 to 35, these are exceptions to hearsay evidence. With this, res gestae is over. Res gestae is over. Next, second topic for discussion is section 7. Section 7, facts which are occasion, cause or effect, immediate or otherwise, of relevant facts or fact in issue. Section 7 of the Indian Evidence Act or Section 5 of the Bharatiya Sakshya Adhiniyam provide for five concepts, 5 instances, 5 situations wherein the facts are considered, their facts are connected. These 5 facts, they are not directly form part of the same transaction, they are indirectly otherwise connected to the main fact. So they are admitted in evidence. Now we come to section 6. Section 6 deals with facts forming part of the same transaction. But what facts form part of same transaction, it is difficult to know, and it is very difficult to arrive at conclusion. That is the reason why section 7 rescued this situation and provided elaborately 5 concepts, namely occasion, cause, effect in first paragraph, and state of things and opportunity in the second part. That is why in civil and criminal proceedings, these 5 topics, though they do not form part of the same transaction, they are causally connected to the part of the main fact or principal fact or transaction, so far as the civil case or criminal case is concerned. Now occasion. So here in villages, fairs take place weekly. Monday, once in a Monday, once in a weekly Monday or weekly Sunday or something. So in that there is a big open land. The vendors and peddlers from sellers from various places meet there, and consumers from surrounding villages will meet there. Right from smallest article to biggest article, including cows, buffaloes are being sold. That is what is called fair, market fair. Suppose a man going to market fair to purchase something, it is an occasion. It is an occasion that he contains a lot of money in his bag. That is occasion. That is occasion. So he has money, but today we cannot get here. We cannot find his money. Coming Saturday, coming Sunday, he will go to market fair with lot of money cash. Then we can let us wait for the occasion of market fair. Then we will. That is occasion. Secondly, Secondly, a man went to bank and has drawn money 5 lakhs or 10 lakhs cash. After drawing money, he is there. He is going. So, the occasion, there are so many, 4 or 5 persons are going, they don't have money. They have little money in their pocket. But this man appears to have lot of money. So, any thief, any robber can attack him and take the money. So, that is what is called occasion. R versus Richardson is the best case covering all the 5 points. R versus Richardson, R state Richardson. Richardson is a man. He fell in love with a poor woman. He consummated with her and made her pregnant. And he may be compelled to marry her. A man from high family or rich family would not like to a poor girl on this. These are the most common things which we find in movies also. So occasion in the sense this man could go and consummate with her because the girl was lonely at home, lonely in her cottage. Alone, the girl was alone in the cottage was occasion to commit the act. That is the occasion. Secondly, occasion. Now, any man carrying lot of money in city bus, but the people having little cash don't care. If a man carrying, putting some lakhs of rupees in pocket or bag, his face will be, there will be some fear. Very often he is touching the pocket, very often he is touching the bag. Like this, it will provide an occasion to some pickpocketer in the bus stop to rob the money or steal the money. Taking money without knowledge of owner, stealing, theft. With his knowledge, taking means robbery. So like this, that is the cause. Next, second one is R versus disaster. The girl was alone. That is why he could. Second one is cause. What is the cause? R versus Richardson. No, he killed. Why he killed? What is the cause? The girl became pregnant. If it is released, it leaked out, the people, his name and fame will come down. Otherwise, he may be compelled to marry a poor woman. That is the cause. With the further cause only, he killed. So, there is a relevant case on this point. Indian Airlines versus Maudri Chowdhury. In this case, there was air crash. The investigating officer gave a report as to the cause of accident. As to the cause of air crash was accepted as relevant in this case. That is with reference to cause. And third one is effect. For any act, some effect will be there, some consequences will be there. Effect will be there, some consequences will be there. Suppose a man runs for more than 1 hour. After running, he is with lot of sweating and in his condition of his face, there is a lot of change. Suppose some murder take place, then blood is there. But someone may have seeing blood, either some man might be killed or some animal might be killed. That is this thing. So some footprints are there. Some animal is walking in this way. That type of effect is there. What is the effect here? What is the effect? So here in R versus Richardson case, what happens if he do not bury this fact? He has to vanish the fact of his consummation with the poor girl and resulting her pregnancy. Effect means the effect of consummation is pregnancy. The effect of pregnancy is he is dragged to, he is required to, he will be compelled to marry her. So the vanish the effect, he wanted to kill the woman. So for effect there are so many things. Suppose if a man consumes poison, some symptoms will be there. Suppose a man, that is effect. If a man is taking right gold and wrong gold, a man who purchased gold with proper bill, he will be daringly carry the bill. Suppose a man purchased gold without paying taxes and other. If a man taking stolen property, stolen gold and taking, if police caught, his face will be, some scratches will be there on this face. That is what is called effect. So that is why section 7 is based on the principle of induction. Section 7 in Indian Evidence Act, section 5 in Bharatiya Sakshi Adhiniyam, based on principle of induction. Principle of induction means whenever particular act is committed, certain consequences will follow. Effectual changes. What are the effectual changes that brought about can be understood. Suppose a woman after pregnancy, her the body condition and face there will be some changes in her body after pregnancy. That is this. So like that after rape, there are some changes on the face and other things of a woman. These are what is called pregnancy. So this concept of effect can be explained with reference to Spencer Cooper's case. In this case, what happened was, a woman was found dead found floating in a tank. A woman was found dead found floating in a tank water. So the question is, the fact in issue is whether she was killed and dropped in waters, or she committed suicide. She jumped into water to commit suicide. That is the question. The prosecution, so when in the post-mortem report, her belly did not contain any water. Prosecution said that since her belly did not contain water, if dead body is put into waters, she will not drink. Dead body would not drink water. The mouth would be totally closed. No water will be there. So then if killed first and then dropped in water, prosecution makes allegation that the woman must have been killed and then dropped in the water. That is the opinion. That is the effect. Because her belly did not contain any water. It did not contain any water. Their belly did not contain any water. Say the other defense side say that there is no hard and fast rule that dead body will not take water in the belly. These are the question. There were arguments with reference to this effect. Effect is over. Next point is state of things. Under what are the things which what are the under what facts, principal facts, the act happened. So there is this. What are the state of things responsible for commission of this particular act? What are the consequential things, state of things that took place? Suppose unexpectedly one person did not come, then another man came and he was subjected to that particular accident like this. So a state of things. So A has to go to abroad, but A is not available. Then B is asked to go, and some good may take place or bad may take place. That is what is called the state of things, we can say. And there is a relevant case on this point is Rotten versus Regina. Rotten versus Regina. In this case, what happened? Husband accused killed the wife, deceased, with revolver. And after killing his wife with revolver, he pleaded a defense that when I was cleaning my revolver and accidentally I knocked the trigger, bullet came out and hit my wife, and then she died. He wanted to escape from criminal liability, establishing Section 80 of Indian Penal Code, accident, to get exemption from criminal liability. But the evidence was so proved that the matrimonial relations between husband and wife were not cordial for the last previous so many days. That is one thing. Second reason, he was having affairs with some woman. He was having sexual affair with some other woman is that relevant. Basing on these two facts, he was convicted. So this is with reference to state of things. Last one is opportunity. Opportunity means for commission of a crime or commission of something, an opportunity must be, there must be some opportunity. In first point, cause also I told, A borrowed money from B. Why? Because the cause is he has no money, he has a deficit of money. That in cause that borrower lender relation we can say. Now last one is opportunity. Opportunities mean circumstances which provide opportunity to for happening of a fact. Some people think that no, what is there? They become brother and sister. They allow them to sleep on the some relation, wrong relation. They allow them to sleep on the same room. But something, the opportunity bodies may touch and something may take place wrong. So that is the thing. So like that is opportunity. Opportunity means nobody is there at home. Oh, a woman is alone. I know unexpectedly some neighbor or somebody came to their home. They started speaking for many hours. That opportunity resulted in their meeting. So this is the opportunity. Like that, here in R versus Richardson is the relevant case. Here, in order to create an opportunity to kill the girl, he left his work, told his inmate he want to go to some place, Smith's shop. He told, I shall go to Smith's shop for 1 hour. I am leaving the work spot. And he went to, saying that he is going to Smith's shop, he directly went to the cottage of the deceased girl and killed her. So with this seventh topic, the next topic, occasion, cause, effect, state of thing and opportunity are over. Next, eighth one is next topic for discussion is section 8. Section 8. Section 8 is next topic. What is next topic? Section 8. In section 8, motive, preparation and conduct. Motive and preparation are events preceding commission of an intentional crime. In commission of a crime, there exists motive and preparation. Motive means object behind commission of an act. Originally, motive refers to good things, malice refers to bad things. Motive includes intention. Intention is immediate, motive is ultimate. Motive is which renders a man to commit an act. To an ulterior is the result of motive makes a man to commit an act. So, in commission of a crime, motive may be present. So, here there are two politicians in a place. So, they may be for MLA, MP or Sarpanch or anything. Consecutively, one man, A is winning. A is winning in the election for the last 3-4 decades. That B, trying all means not able to get elected. Then B, until and unless this man die, I cannot get elected. If he says like that, no. But no, I must get elected this time for this purpose. From next election, I must get elected. Meanwhile, I have to kill him and let us take necessary efforts. He told somebody, I give you this much money, you go and kill him, like that. So that is what is called the motive behind killing the opponent, political opponent, is to get elected in the ensuing election. That is the motive. Secondly, A killed B. When A was killing B, C saw the commission of the offense. Then immediately after killing B, A will pursue C. In case I don't kill C, C will give evidence outside. She will tell to other. Police will catch me and I will be convicted. So if C is alive, there will be a danger for my life and security. That is why I must kill C. So the motive behind killing C is to vanish the evidence. Vanish the evidence. Similarly, A killed B and the body is cremated. The body is thrown in sea, or the body is cremated by burning petrol or something to vanish the evidence. So that is why motive and preparation are important conscients in commission of a crime. With this reference, there are so many things are there in Indian Penal Code. I told there are four stages of crime. You see, intention, preparation, attempt, and accomplishment. I told in abetment, IPC abetment topic, I told four categories of criminals: abettor, principal in the first degree, principal in the second degree, accessory before the fact, accessory after the fact. Principal abettor means a man who engages other to commit a crime. He is abettor. And the person who killed with his own hands is the principal in the first degree or principal offender. Number two, since principal in second degree, if mother instigates a son to kill wife and get she remarried, then the mother is principal in the second degree. The son who killed wife with his own hand, principal in the first degree. Suppose a man has robbed money, run away and hiding and to hide in a house. The person who gives shelter to hide in the house is principal in the accessory before the fact, or accessory before the fact, and accessory before the crime. No. The person A want to kill C, B want to kill C. A is running to kill C, but B gives him vehicle or revolver. Then B is accelerating the crime, speeding the crime. Then B is accessory before the crime or accessory before the fact. And A who provides necessary equipment, revolver, bulletproof coat, bulletproof car, everything to commit the crime. The person who has provided intentional aid, that man is called accessory before the fact or accessory before the crime. After crime is over, who gives shelter to that culprit is called accessory after the fact. These are the things is there. Intention, the idea to do committee in mind is intention, and to get it fructified initiative is taken, that is motive. And then necessary preparation is made, that is the purchasing of poison bottle to give poisonous food, or purchasing deadly weapon, or purchasing or procuring revolver. These are the acts, preparatory acts, that is the preparation. So intention, preparation, motive, or intention and preparation, motive and preparation are the conscience in a criminal act. But whereas conduct, with reference to conduct, the conduct may be previous conduct or subsequent conduct with reference to commission of the crime. The accused are a party to the person in a civil suit or criminal suit. In criminal suit, the accused are either accused or accomplice. in civil suit, party to the suit or agent, authorized agent of the suit, the conduct will be relevant. The conduct of a person will be taken into consideration as relevant in commission of a crime. So, for breach of contract or other civil litigation, the conduct of a party to the contract, a party to the suit, or authorized agent of a party to the suit. In criminal law, either accused or accomplice, abettor, whoever may be, their conduct is to be taken into consideration for application of this. So the motive, so far as now, let us now discuss about with reference to conduct, whether the conduct influences on the whether the conduct influences on parties, or the parties may it may either the conduct influence them or they are influenced by the conduct, and then that conduct is treated relevant for admission in evidence. This is with reference to motive, preparation, and conduct, previous conduct or subsequent conduct. So, section 18 speaks about three principal facts relating to civil and criminal cases. They are motive, preparation, and conduct. The conduct may be previous conduct or subsequent conduct. Coming to the topic, motive. Motive means reason behind commission of an act, a commission act. It leads a man to do an act. It is an ultimate, it is an act, in which object to be achieved. So, A kills C for the reason that C may C saw while A killing B. C may blackmail him or extort him for money. And that is why A also kills C to vanish the evidence. So after killing, the body is cremated to vanish the evidence. So like this, motive plays an important role in commission of the crime. But the question is whether the volume of motive or advocacy of motive is not relevant. Is not there is no the adequacy of motive is no way concerned. For heinous crimes also small motive may be there. For small crimes also big motive may be there. So the volume of motive is not there. For insanity, for pleading defense of in insanity cases, if the accused pleads the defense of insanity under section 84, the motive need not be present. So the motive is not, because of the reason that the motive is present, the person cannot be convicted. So the motive is a corroborative evidence. It will help the situation, but not merely because of the motive, the person cannot be convicted a person cannot be convicted purely on basing on the motive. So even without motive, the person may be convicted on other grounds of evidence. So motive, preparation, and conduct are taken into consideration where there is no clear evidence, where there is no direct evidence. But what all topics we are discussing from section 6 to 55, there is no any direct evidence. All these things are relating to indirect evidence only, circumstantial evidence only, alternative source of evidence only is what we have to know. So this is with reference to Sukram versus state of the relevant case is there. Sukram versus state of Madhya Pradesh. Motive is not relevant if other evidence is adduced. In the event when the complete other source of evidence is there, motive need not be necessary. When direct evidence is there, where is the need to take into consideration indirect evidence? When documentary evidence is there, there is no need to take oral evidence. When direct oral evidence, if oral evidence is not there, indirect evidence is hearsay evidence is taken. If direct evidence is not there, indirect evidence will be taken. Next, Kandula Bala Kandula Bala versus state of Andhra Pradesh is one relevant case is here. Relevant case, what happened in this case was the accused is son-in-law, the deceased is mother-in-law. Mother-in-law before marriage, mother-in-law promised son-in-law to give some land. But after marriage, mother-in-law did not give land directly to the son-in-law, but she gave that land in favor of daughter, for which son-in-law is not happy. Why you promised me to give land to my name, but you are giving the land to your daughter? Then he got angry and killed. So in this case, if the person is killed, if wife is killed, then the property will come to the property will come to his name. With that motive, he has committed this offense. And the next one is preparation. Preparation means arranging the means for commission of an act is preparation. So purchasing poisonous bottle, or procuring or purchasing poisonous bottle, procuring or purchasing a revolver or axe, knife, etc. will come under this category. So in this case, what happened was Mohanlal versus Emperor. Mohanlal versus Emperor. Preparation. In this case, the accused imported some goods. He is supposed to pay some excise duty. So before to avoid excise duty, prior to importing of the excise goods, he visited the excise department personnel, made certain arrangements, made certain preparations that the goods will come without tax and to avoid the tax. So what are the visits he made previously to arrange the needful is treated as preparation, which is relevant for commission of the offense, was decided in this particular case. Lastly, conduct. Conduct may be previous conduct or subsequent conduct. So the word conduct means behavior of a person. The character, conduct and character are synonymously used. But one thing, conduct is the opinion, impression of the impression about the nature of a particular person. So conduct is what others think about him. So the conduct is relevant in certain cases, and they could conduct while determining guilt on a particular person, the conduct sometimes will be taken into consideration. The conduct sometimes will be taken into consideration. In civil suit, in criminal cases, the conduct of accused accomplices will be taken into account. In civil suits, parties to the suit and their authorized agents of the suits will be taken into consideration for admissibility of the conduct. So here what happened is there is a relevant case in this point. What is the in this conduct can be explained with reference to two things: previous conduct, subsequent conduct. Previous conduct in stages of crime, accessory kinds of criminals, accessory before the fact, accessory after the fact. I tell you. Suppose A wants to kill B, A wants to kill C, B also wants to kill C. But A is running behind C to kill. A started running C to kill C. B, whose mind is who has intention to kill C also, when A is already trying to kill, so why should I? Then he gave vehicle or he gave revolver to kill him from distance. Then B is called accessory before the fact, that is previous conduct, that refers to previous conduct. Subsequent conduct, suppose A killed C, after killing uh, after A killing C, D helped him to cremate that body, vanish the evidence, and D gives shelter to A. That is what is called subsequent conduct. Then subsequent conduct will be taken into consideration. Helping whoever helps for destroying, whoever helps to commission of the crime is previous conduct. Man with previous conduct, whoever helps after commission of the crime, subsequent conduct which are relevant under the Indian Evidence Act. Please bear with, dear friend. One more section is there. So there is one previous conduct is there. So Bal Mukund Ram versus Ghanshyam Ram. In this case, what happened was the tenant entered into landlord's house, into their bedroom, where landlord and his wife were sleeping, and he wanted to then the conduct of the tenant was found relevant for the purpose of arriving at the conclusion in this case. So these are the various some cases also are there. There is no time to discuss so many cases. And the last one is Section 9 in Indian Evidence Act, Section 7 in Bharatiya Sakshya Adhiniyam. What are the 7 intention? Facts which there are 7 cases. Facts which are necessary to explain fact in issue or relevant facts. Facts which are necessary to introduce fact in issue or relevant facts. Facts which support inferences suggested by facts in issue, relevant facts. Facts which rebut or contradict the inferences suggested by fact in issue or relevant fact. They are not even direct, they are only inferences. Inferences means assumption. A is not in office, but he might be at home. That is inference. He is not in home. He might be in club, like that. They are the inferences. So though the facts are not directly relevant, indirectly relevant, but they suggest some inferences. These facts neither directly connected nor indirectly connected. They give only certain suggestions, inferences. Some inferences suggested by the fact in issue and relevant facts are treated. That is what Section 9 in Old Act, Section 7 in New Act tells you. Section 9 in Old Act, Indian Evidence Act, Section 7 in Indian Bharatiya Sakshya Adhiniyam provide for 7 situations. One is introductory fact, second one is explanatory fact, second one is introductory fact, third one is facts supporting the inference suggested by fact in issue and relevant fact. Next, fourth one, facts rebutting or contradicting the inferences suggested by fact in issue or relevant facts. Section 5, fifth point is identification test or test identification. Section 6 is facts which fix time or place at which fact in issue. So where the transaction took place, where the offence took place, the time and place. That is alibi. Section 11. In Section 11, we study in detail about alibi. And Section 5 speaks about test identification. Section 6 speaks about alibi. Section 7 about family relation, that is ancestral friends. These are the main topics, dear friend. So the first topic, the all topics are very small, but fifth topic, test identification or identification period, is a very big topic. Very big topic. Coming to the facts which necessary to explain facts in issue or relevant facts or explanatory facts. So there are certain situations, there are different facts. Every fact itself does not convey any meaning. There are 3 or 4 facts. Every fact individually or independently conveys no meaning, conveys no relevancy. They are not relevant, they are not accepted. But two facts or more facts are jointly connected, jointly presented, then the relevance is created. Simply speaking, one chapel is of no use. Two chapels are, it will be useful. If that is why if anybody one slipped from train, he threw the second chapel also, like that. So a fact is, there are so many facts, there are certain circumstances which there are different facts. All facts are not do not have any piece of evidence. So one individual fact is not does not convey any meaning. It contains no meaning, no relevancy, not allowed. But two or max four facts are united. That is a relevant fact. That fact is admitted. That fact is admitted. No, that is, they are called explanatory facts. And the second one is explanatory facts. So here there is a relevant case on this point is Nur Muhammad versus Emperor 1944 case. In this case, accused is Nur Muhammad. He abducted a girl. Means kidnapped a girl. When he abducting the girl, this girl cried at her brother. Brother, someone is taking me away. Then on the same day, this boy was loitering around the police station. The girl, when the boy was loitering, the police station, girl's house is side by side, and the boy is loitering around the girl's house. Indirectly, he is loitering around the police station. Suddenly, he found the time and took the girl away, abducting. When he is abducting the girl cried for his brother for help. Then after that, the girl made a statement to police. Out of the abductor, the culprit is one among them. So Nur Muhammad is one among the abductors. So the statement of that girl was considered as introductory fact, explanatory fact, and he was arrested and convicted. So that is the thing. Next, second one is another important case is Rohan Lalu versus Emperor. Emperor means king. Is a culprit. Rohan Lalu, what happened here was, in this case, a man, the accused, Rohan Lalu, he killed his wife with axe. Then his 5-year-old child started crying. On hearing the cries of the child, the surrounding people came. The statement given by surrounding people at the cries of the child were found relevant. They are treated as explanatory facts, and the accused was convicted. So regarding that, similarly, there is another case, Emperor versus Abdul Ghani. Emperor versus Abdul Ghani Bahadur Bhai. Emperor versus Abdul Ghani Bahadur Bhai. What happened in this case? This accused in this case managed 4 bank drafts. He encashed 1 bank draft. When he went to another bank to encash the second draft, that bank received a telegram. The telegram from the authorities, so and so 4 drafts were found missing. If they don't pay any payment, they received the concerned banks received telegrams requesting the bank authorities to countermand the payment, countermand the drafts. So here This culprit was caught at the second stage, and the statement, the telegrams were considered as explanatory facts, and the accused was convicted. That is, explanatory fact is over. Second is introductory fact. There are these introductory facts are most important facts. The court needs the introductory fact. Without the introductory fact, the court will not be in a position to arrive at the conclusion as to the factual position and to deliver pure and impartial justice. So the introductory facts are very important while deciding the case. So third one is facts which support the inferences suggested by the fact in issue or relevant facts. Suppose A is killed, B his nearest relative whereabouts unknown, he is absconded. So the so and so X A is killed, B is not whereabouts not known, but mean B must have killed him. That is the inference suggested by fact in the issue or relevant fact may be treated as ground. That is, facts which support the inferences suggested by fact in issue or relevant fact. If a man is absconded, if whereabouts are known, if he is found, if the evidence is suppose somebody died in the family, the body is not kept for long time, immediately it is cremated. So when it is cremated immediately without waiting for DR, there is something wrong. There is something wrong in that. Some inference will create that. That inference suggested by fact in issue or relevant facts will be taken into consideration as relevant fact for the purpose of this case. That is fact. Third, contradicting. Facts which rebut or contradict fact inferences suggested by fact in issue or relevant fact. For example, A died. The allegation is B killed. But luckily how B can be killed? B is very weak. He underwent a treatment. He underwent open heart surgery or bypass surgery or kidney transplant. He is not able to move from the bed. How he will be able to kill? So the facts which rebut or contradict the inferences suggested by the fact in issue or relevant fact is the example. The person who is undergo treatment unable to move will this. The fifth one is most important topic. The fifth one is identification of persons or identification of persons, things, identification of persons, things, even animals also. So judicial officers in their article mentioned judicial animals also. Now dear friends, over 2 minutes wait. Please cooperate for few more minutes. And now fifth point, facts which establish the identity of anything or person whose identity is relevant. So in certain cases the identity of person is important. The identification of persons or things or articles or animals. So in criminal proceedings identity is very important. The concept of identity or identification or test identification is not there in Evidence Act or Criminal Procedure Code till 2005. In 2005, amendment was made to CRPC, namely the the Code of Criminal Procedure Amendment Act 2005 was made. By this Code of Criminal Procedure Amendment Act 2005, a new section 54A has been added to Criminal Procedure Code. This new section 54A makes provision for conducting identification tests or test identifications It also makes provision for organizing identification periods or test identification periods. In this case, if the real culprit is not traced out, there is a doubt about some previous habitual culprits. The habitual previous culprits or accused criminals will be called for police station or jail. Generally, the test identification period either may be held at jails or in police station or at elsewhere in the presence of magistrate or source witnesses. Or some responsible persons. Here we see, dear friend, suppose a woman is going on the road, one motorcyclist snatched her chain and ran away. She partly saw him. She will be able to identify. She went to police station and lodged a complaint. While I was going on the road, one motorcyclist snatched my chain and ran away. Okay, then you will go. We will look into the matter. The station house officer or head of the police station, officer of the police station, according to section 54A, will request the court of local jurisdiction, that is magistrate, giving him an opportunity to conduct test identification. At the request made by police officer of the police station, the concerned court magistrate may give an order to hold identification test or test identification to identify the real culprits. To that effect, basing on that, some identification period or test identification is conducted. It may be conducted in jails or it may be conducted in the police station or elsewhere in the presence of magistrate or some witnesses who are responsible persons or learned persons in that area. And suppose in one movie, hero abducts a woman from marriage venue and takes her to her lover and get this girl married to that boy. Then in the marriage venue, heroine found this hero and test identification was conducted. Identification test was conducted. The hero who abducted the bride was one among the 5 to 10 previous criminals of similar type. This heroine identified that hero as the culprits who abducted that girl. That boy who was identified by this heroine was taken into custody and was punishment was charge sheet was FIR was lodged and follow up steps, investigation, inquiry and everything took place. Subsequently, that boy went to ladies hostel, that girl and tell it is in one movie. So this is the test identification. In test identification, the woman who lost her chain snatched by somebody will have to identify some other chain snatchers who are there. She will have to identify. And the stolen property is there, so many chains are there, so many jewelry is there. She will have to identify what chain is hers. That is identification of ornaments. So in identification of animals also will be there. For establishing center rule in civil cases, whose dog bit you and whose animal bit you, damaged you. For those things also, the animals also may be identified. So this is what is called test identification or identification period point number 5 is very important. So this identification period may take place in investigation stage, or sometimes in trial stage also is there. It is there in some cases in article published by two judicial officers. At trial stage also, a test identification may be taken. Test identification may be taken. So the identification at the order given by the magistrate or the court, local court, the police officer can conduct the identification period either in a police jail campus or in police station campus or elsewhere in the presence of magistrate or punch witnesses. Punch witnesses means some responsible persons, teachers, principals, professors, officers also may be required to be punch witnesses. In this presence, the culprits, accused, previous accused will be there, and aggrieved parties will be there. The aggrieved party will have to conduct. The aggrieved parties, the witnesses may be two or more, maybe one person or two or more, like this. So here to identify one accused, identification periods may be organized. For to identify two or more accused also, test identification may be conducted. So what is the evidentiary value? The identification period is not a conclusive evidence. It is not final. It is only corroborative. So it is only if when a case is to be finalized in the criminal case, first investigation is there, next enquiry is there, next trial is there. The question of law can be raised. The question of relevancy as to a particular fact can be raised at any stage, right from investigation to trial. So that is why if a person is identified as a culprit, as accused, he is not final, but follow-up action also will be complied with, then only conviction can be given. Conviction can be given. The object is to identify the real culprit, and the object is to test the capacity and caliber, ability of witnesses to identify and pick out from group of culprits, or identify and pick out the stolen property from number of articles. So there are so many others, so many settings are there. Test identification. If you want me give very big lecture on test identification, you please put SMS. I will cover this. So fifth point is facts which fix the time or place of facts in a issue and relevant fact. This refers to ALIB, ALIB, section 11. In section 11, I will explain in detail about ALIB in following topic. ALIB means the accused person tries to escape from the liability. The accused person depletes the defense of resorts to plea of ALIB. No, the offence took place in Madras at so and so center, but at that time I was in Bombay undergoing treatment, or I was in some cricket match, I was in some other engagement, I was in undergoing treatment, like that. So one man cannot be made available in two places. So ALIB is like a defense to get exemption from the criminal liability. This topic speaks with that. And the last topic, seventh topic is facts which show the relation of parties by whom such fact was transacted. This is reference to the parties. There are certain circumstances, the relatives of the transaction, the relatives of the relations of the parties. In civil litigation, plaintiff and defendant or petitioner respondent are the parties, their relation. In criminal law, criminal proceeding, prosecution side and defense side, they will have the accused relatives or victims, victim or deceased relatives also may be called for called for to give evidence, then the statement with reference to pedigree friends also will be there. Pedigree friends means ancestral friend. For this, there is no any complete explanation in any textbook, dear friend. So these are the seven. So evidence given by the relatives of the parties to the parties. That is plaintiff side, defendant side, or petitioner side, respondent side, or appellant side, respondent side in civil litigation, or prosecution side, defense side in criminal proceeding. So though they also, their inferences also may be taken into consideration for evidence. Thank you very much for your patient hearing. This is a very lengthy topic. So all these five sections come under one umbrella, one shadow. That is why I have completed this topic. Thank you very much. If you find it lengthy and difficult, you make it into 2-3 parts. Download it and make it 2-3 part section wise and follow, dear friends. So convenience only I have tell. In future section classes will be around 1 hour only. Thank you very much for your patient hearing. You watch all my videos and you cooperate with me, and kindly put my videos in playlist. Kind you share my videos, inform my videos to your friends, and share me as a partner in doing this service. Thank you very much.